This program is sponsored by Tilson Solicitors.
Assalamu alaikum, hello and welcome to another series of Legal Forum here only on the Islam channel with me, Lee Clark. Now the Legal Forum is a program where each week we discuss common topics in layman terms to help guide you with legal advice. Breaking down the complex language of law, the Legal Forum will also highlight real-life cases and scenarios. Please, however, do bear in mind that views and opinions expressed in the Legal Forum should be considered for informational purposes only and not case-specific legal advice. All topics are discussed in a generic nature, and it's important that you consult either with a CAB, law centre or a solicitor before relying on it. Now, in respect of Islamic wills, this will be our first topic of discussion, explaining how you can have a Sharia-compliant will that will satisfy the English law requirements for a valid will and mitigate inheritance tax. To discuss today's topic, I'd like to welcome al-Bukhari Shah, a solicitor with over 20 years of experience in criminal law, but in the last few years, after drafting a will for a friend who performed a pilgrimage to Mecca, his interest and research grew. It's a pleasure to have you with us today. The law, as it stands, is the English law, the British law. How does that vary with making a will, of course, with Sharia?
Well, a Sharia-compliant will, it's obligatory in Islam. The Prophet Muhammad, peace be upon him, said that a believer, if he has anything to bequeath, must not spend more than 2 nights without making a will about it. It's also mentioned in the Quran that it's the duty on the righteous to make a will which is equitable for family and friends and relatives. So it's a legal duty. An Islamic will is not recognised under English law, and therefore, if you're going to have an Islamic will, you must make sure that your Islamic will complies with the requirement of an English law.
Now, as far as principles go, what are the basic principles somebody needs and requires to have a will set up coming along when they come and visit you for the first time?
An Islamic will?
Yes.
Well, really, when you attend a solicitor's office, they first of all will take instructions off you in regards to your beneficiaries, specific gifts you may make. They'll also take into account your assets and your liabilities to work out what net estate you have, because you need that to work out how to minimize inheritance tax. But the basic structure of an Islamic will is that from the estate, which is the deceased person's wealth, you take away the funeral costs, and thereafterwards you pay off his debts. Thereafterwards, 1/3 you can bequeath to anyone you want, and 2/3 has to be distributed according to the law of Sharia.
Now, the other side of it is, a lot of people, when we've done our first season here, is the fact is people are wary of who they should trust, who they should go and see, also cost implications. Is this something that is a big cost for somebody to kind of set back as far as fees are concerned?
A basic will does not cost a lot. If your estate is below the inheritance tax threshold, which is at the moment 325,000, then it doesn't cost a lot. But if your estate is very large and you need to minimize your inheritance tax, then it will cost more. It really depends on how complex your will is.
So an average time frame for somebody coming to visit you, Shakil, I mean, to get, so let's say if there is such a thing as a normal average will, an Islamic will to set out, what time frame should somebody be looking at to achieve that?
I would say for a basic will, 7 to 10 days,
okay.
And a more complex will, which requires extensive inheritance tax planning, about 3 to 4 weeks.
And as far as the Islamic will itself is in situ, writing that in a form of English law, how complex is that, and is that kind of something that's pretty complex to do and start?
There's certain formalities that an English will requires, which is you must comply with Section 9 of the Wills Act 1837, which means that the will must be written, signed by the testator, the person making the will, in front of 2 witnesses, and the 2 witnesses sign the will in front of him. Thereafterwards, you can set out that you want your estate to be distributed under Sharia law.
Now, what's the kind of main worry that people have, or the main kind of hurdles you have to jump over to start? I mean, is there any problematic areas that people can help themselves before they come to get a will sorted out?
Well, the areas that you really need to consider is minimizing inheritance tax. You also need to work out you need to make sure you know who your executors are. Mm-hmm. Executors are people who gather your assets, pay your debts off, and thereafter distribute your estate. If you've got young children, you'd want to make sure you have guardians. It's good practice to ensure that your guardians are informed that this is what your intention is and whether they agree. Because there's nothing worse than someone turning up with 2 children and go, there you go.
There you go.
Look after them.
They're all yours, yeah.
In a will, of course, you can also set out what you want to happen to your body. You may not want your organs to be donated for medical purposes, or you may not want your body to be transported to an Islamic country because the body would need to be embalmed, quite possibly with alcohol, which is haram. So you can set out in your will how you want to be buried, where you want to be buried. So you have your guardian, minimizing inheritance tax, choosing your executors. They're the main areas I think you need to be thinking about.
I think as far as part of a will is concerned, it's probably one of the key things that anybody will do in their entire life. I mean, buying a house, maybe starting a family, getting married, or whatever it is they do. But certainly a will is up there as one of the key important decisions that anybody will ever make.
Well, nobody wants to think about death, unfortunately, but it's important that you start making provisions, because if you die without a will, the intestacy rules apply. And there's a statutory distribution and the Administration of Estates Act which sets out who receives what. Now, from an Islamic point of view, if you're married to a Muslim person under Sharia law, in this country, that wedding is not recognised. If you haven't had a civil ceremony and you die, then your wife will receive nothing under the intestacy rules because the marriage is not recognised, and the law treats your partner almost as an unmarried common law partner has, so they won't receive anything.
So it's got a kind of basic kind of formalities that you have to go through, and obviously with the guidance of somebody like yourself, that's a real big help. I know this might seem a silly question, but is there an age limit that you can, before, I mean, I take it you have to be an adult of 18 to set out a will?
A will in English law, you have to be 18 years of age unless you're in the military on active duty, in which case you can have a will below that age. But an Islamic will you can make when you've reached puberty. So not only can you make a will when you've reached puberty, but you can also receive property when you've reached puberty. If you're below puberty, then a relative will look after your interests. Whereas in English law, if you receive property and you're under the age of 18, then it's looked after, well, that property is looked after on trust by your guardian.
Okay. Now, consequences of, for instance, if you don't get married, you're single, you have property, you have assets. If you don't make a will, what happens if something happens to you?
If you don't make a will, the rules of intestacy apply.
Yeah.
And there's a statutory distribution. So if we have a look at it on a point of view that if you haven't got a will, then, and you're not married and you don't have any children, then your estate will go to your parents.
Okay.
If you are married Islamically, but you've not had a civil ceremony, then your partner would receive nothing, but if you have children, they would. So there's a distribution. The way it normally works is wife, children, parents, brothers and sisters off the half blood, means stepbrothers.
Is there a common problem that you have to go, right, here we go again, we have to deal with this situation because somebody hasn't done this or the foresight hasn't been there? Is there something that you deal time and time again with?
The biggest problem I seem to come across is a lot of the clients are married under Sharia law, but they've not had a civil ceremony. And if you want to look after your wife, then you'd want to make sure you have a will. If you don't have a will, obviously the rules of intestacy apply, but your wife can make an application under the Inheritance Provision for Family Independence Act to say, or to make an application to say that she was financially dependent on you, but that costs money. Why would you need to spend that amount of money on legal costs when just making a simple will would do?
The thing that we mentioned earlier on, the conversation, the topic of inheritance tax is something that I think is going to be of interest to everybody, because you want to try and pass on as much as you can to your family or the people that you choose to leave it to. I mean, how important is that as a key box to tick to make sure that you can give as much of your assets to whomever you'd like to?
Nobody likes paying tax, but it's even worse with inheritance tax, which is really a hated tax in the sense that you worked all your life, you've paid your taxes, and then when you die, you have to pay more taxes than what you bought. So in England, there is an inheritance tax threshold, which is the amount that your estate could be worth before you pay inheritance tax. That at the moment is 325,000.
Who values that? Because that's the thing for me. I was always, when your estate could be worth, do you have to get like an estate agent in to come and value your house and your car?
It's your executors.
Right.
It's your executors. They will first gather all your assets, pay all your debts and your creditors off, and then after they've done that, they work out what the cost of the estate, well, what the estate is worth, and then on that, inheritance tax is paid. So, for example, if I was to die today and if I was unmarried and my estate was worth 425,000, from that you would take away 325,000, which is the inheritance tax threshold. That leaves 100,000. Well, that is taxed at 40%.
Okay.
So I would end up, or my estate would end up paying £40,000. So if your estate is worth, and considering that property prices have been moving up in the southeast and some people have a number of buy-to-let properties, you could easily be paying hundreds of thousands in inheritance tax.
Well, I was just about to say, the way the property prices are going, not only with the southeast of England, but all of the places around the United Kingdom, it's, if you have multiple properties especially, it's of key importance to make sure. So under English law, under British law, how do you minimise then inheritance tax? What's a way that you, in your form, will advise people how they can minimise, obviously legally, the way for minimising that?
Well, the first step you need to do is actually work out what your estate is. So if you draw up a table in terms of what your assets are and what your liabilities are, that gives you a good idea of what your estate is. And if it's worth more than 325,000, then it's time to start taking steps to minimise inheritance tax. There's a number of exemptions which, while you're alive, you can take advantage of. For instance, you can give an annual exemption of £3,000. Okay. The £3,000 is specific to you. So if you're married, your wife can also make a gift of £3,000, and that's every year. If you're allowed to bring last year's over into this year if you haven't paid, so you can actually end up giving 6,000 away. Now, if you give 3,000 away, or say over a period of 10, 15 years, that's a lot of money that you can use to reduce your inheritance tax. Additionally, you can give £250 to any individual you want. You can make a potentially exempt transfer, which is a transfer that you make out of your estate, and provided it's more than 325,000 and you survive 7 years, then there's no inheritance tax to pay. So you minimise your wealth that way. If you die, say, after 3 years, then there is inheritance tax to pay. And then between 3 and 7 years, there's a tapering effect where you pay less tax the longer you survive. So after 7 years, there's no inheritance tax to pay.
I see. Now, here's a question for you. This is where my minds and my cogs start churning here. Can you backdate that? So what you just said, you can offset £3,000 a year for the 10 or 15 years. Can that, if somebody comes to visit you, can they say, well, can we backdate that till 10 years ago that I or my partner has offset £3,000? Or does it have to be from day one? Is there a way of backdating it?
I wouldn't want to say that you can backdate it. However, if you have given gifts away without thinking to yourself at the time that this was part of a gift, you can act, if you make your record and say was a gift of £3,000, then obviously when HMRC comes to see your record, if they want to see your record, you can show them the money you've paid in terms of £3,000 paid. The other thing I want to mention very quickly in terms of minimising inheritance tax is if you're married and you have your inheritance tax threshold of £325,000, when you pass away, you are allowed under the rules to pass that inheritance tax over to your wife.
Okay.
So when she dies, not only would you have her inheritance tax threshold of £325,000, but also your inheritance tax threshold of £325,000, which comes to £650,000 that you can have before inheritance tax is payable at 40%, which is a reasonable amount of money.
Well, I think when you consider it, if you've got family involved and people you want to bequeath your money to, then every penny, obviously, or every pound or every euro, in some cases, obviously counts, doesn't it, really?
Yes, it certainly does.
What's the key thing that, say, parents or adults or married couples come to you and have a Sharia law, or will, put into place? What's the key thing they want to make sure is covered going forward? Is there an area or a topic, or is the will covering a whole genre of topics?
A solicitor will take full instructions from the client, and if the client has missed out any areas, the solicitor would actually bring it to their attention.
Okay.
The key area really is, if they have children, is to ensure that the children are looked after. If they're married Islamically, you would advise them to have a civil ceremony to ensure that they can take example of the spouse exemption.
Now, is there any kind of if you didn't have obviously your Sharia will formatted into obviously under English law, would you end up paying more inheritance tax if you didn't do that procedure?
Well, then you would have died intestate.
Okay.
And if you died intestate, the statutory distribution will take place, and your wife would receive, well, nothing really. Your children will receive something if you have children, but the only way then your wife would be able to receive anything would be if she makes a claim to the court.
Now, obviously, you started 20 years ago as a criminal lawyer, and laws may slightly change from time to time of what thresholds can be reached and what thresholds can't be reached. With wills and compliant wills, Sharia wills and law, how often do the goalposts move? I mean, for instance, do thresholds change with the budget every year?
It does. This particular threshold of 325,000 has been frozen for some time. It changes depending on who the Chancellor is and whether there's election. At the moment, of course, you're reading in the papers that inheritance tax, the hated tax, is going to be changed, or you pay less tax. But, this is what normally happens during elections, where politicians are looking for votes.
For votes, exactly, yeah. I mean, as far as that goes forward, I mean, is it? I suppose what I was trying to think of is how often for you as a solicitor in this field have to kind of read up on the latest changes? Is it only when the budget happens, or is it when a new government takes in place?
You would obviously pay attention to case law.
Yeah.
You'd pay attention to any changes that are made in terms of inheritance tax, capital gains tax, because we're not here to talk about trusts, but you can also use trust to preserve your assets for future generations. So you need to keep abreast of the law, and if you don't, then really, if anyone makes a claim against you, it's your fault.
Of course it is.
For negligence, yeah.
Well, I say what we've covered in the show today, obviously, is the need for the will in the first place, the need for to be legally binding under British law as well, because that obviously helps all your assets go to the places you want it to go to. I mean, any other kind of, from your point of view, important aspect that is really it's very important for a couple, an individual, to think about before they enter into this?
I think if we look at it from the Islamic perspective, it's just so people have an idea in terms of what it entails. Obviously, when your estate is gathered, you pay off your funeral cost and then you pay off your debts.
Okay.
Now, 1/3 you're allowed to distribute to whoever you want. Now, it could be to relatives not entitled under the 2/3 shares. It could be for the upkeep of mosques. it could be for charity. The other, now, the question really arises is, how do you know in the future, what your estate would be, and if you've distributed more than 1/3? Well, in that scenario, that gift would either be reduced proportionally to make sure it is 1/3, or the beneficiaries under the 2/3 all agree to receive a lesser amount, in which case the gift under the 1/3 will go through. Now, I know this is getting complicated.
No. My eyes didn't glass over, I promise.
Trying to make it as easy as possible. Now, the 2/3, the rules, the actual distribution is set out according to the Quran, and it can get very complex depending on what family member survives you. So, if you go on the internet and type in inheritance calculator, Islamic ones, you list the number of relatives you have, and out will pop out what everyone should receive. Now, you can then check that with a scholar to make sure that's all correct, but it gives you an idea of what everyone would receive. And of course, once you have an idea what everyone would receive, you can then make plans to minimize inheritance tax.
Well, listen, in this very short programme, half an hour, we've covered a whole genre of topics, Shaquille.
I hope I'll try to make it as easy
Listen, I
as
have to
possible.
say, it's been an absolute pleasure. And I feel like I've just taken in from all of your many years of knowledge. And I'm sure we'll be seeing you again here on the
Thank you very much.
Thank you very much, Shaquille.
Thank you.
Well, unfortunately, that's all we have time for. I'd like to thank my guest, al-Bukhari Shah, for giving us an insight into Islamic wills. We must stress, as always, that the views and opinions expressed in legal forums should be considered for informational purposes only, and not case-specific legal advice. All topics are discussed in a generic nature, and it's important that you consult either with a CAB, law centre or a solicitor before relying on it. If you'd like any more information about the Legal Forum or the topic we discussed today, then please do, as always, email us at legalforum@islamchannel.tv. Thanks for watching. We'll see you next time. Assalamu alaikum.
This program is sponsored by Tilson Solicitors.